this close to sending your idea out into the world.
People Management Association of the Philippines. People Management Association of the Philippines. People Management Association of the Philippines. Philippines.
Good afternoon. Welcome to the People Management Association of the Philippines webinar on the subject Contractual Obligations and COVID-19, Managing Contract Crisis in the Philippines. My name is Julius Raboca. I'm a lawyer, partner of Vera Law, and I will be your moderator for today's webinar. As we are physically distant due to quarantine restrictions, we are seeing each other in the digital world. On that note, please bear with us in case we encounter technical difficulties along the way. For the past months or so, we have had a series of webinars with a total of over 18,486 Zoom registrants, and we have a weekly reach of 535,933 plus attendees with 146,987 YouTube live views. We consistently have a good number of participants signed up for our webinars. Though Zoom may have limitations in terms of capacity, we still opted to keep the registration open to accommodate everyone. Aside from Zoom, we are currently streaming on PMAP's YouTube channel. If you cannot access the Zoom link, please go to YouTube and hit the subscribe button. Please type People Management Association of the Philippines or search for @official PMAP 1956. That's @official PMAP 1956. Worry not, because PMAP's webinars may also be accessed on its Facebook page. For your questions, please use the Zoom chat box. For those watching on YouTube or Facebook, please post your questions in the comment section. I encourage everyone to take advantage of this free legal consultation, courtesy of PMAP and, of course, our guest here, Attorney Amoroso, because after the question and answer, after the Q&A, the consultation will cost you about $500 an hour. Just kidding. As always, presentation materials are one of the perks of being a PMAP member. For PMAP members who wish to have a copy of the slides, and for those who wish to be a member of PMAP, kindly email via .paragza@pmap.org.ph. Joining us today, it is with great honor and privilege to introduce to you Attorney Dranel Jared P. Amoroso, a senior associate in Kusumbing Torres' Dispute Resolution Practice Group. He currently heads the firm's Transportation and Logistics Industry Group subsector. Let us all welcome Attorney Amoroso, who will drive us through contractual obligations and COVID-19, managing contract crisis in the Philippines. Tanyero?
Thank you very much, Attorney Julius, and good afternoon to everyone from PMAP. I am actually very happy to finally join one of your meetings. As I mentioned to the PMAP team and Jet and Attorney Julius, it's usually the employment lawyers in our firm who join the PMAP meeting. So it's really an honor for me to be presenting to you under these very special times, no? So just to get this out of the way, aaminin na namin sa inyo ni Attorney Julius that we are wearing shorts.
Talaga. But of course, we still look good. We still look good. Yeah.
Which is the only thing that matters.
Yeah.
Okay, so hold on. I will share my screen so that we can begin with my presentation. Okay, Attorney Julius, is the is the presentation showing in full screen?
Yeah, yes.
Okay,
You can see it, yes.
sige. Okay, so again, good afternoon, everyone. Thank you very much for spending time to listen to this interesting webinar brought to you by the PMAP. So as Attorney Julius mentioned, I am from Kisumbing Torres. I am a senior associate in the firm. I am with the Disputes Resolution Practice Group, the litigation team. And I am presenting to you today a sort of a briefer on what this force majeure is in light of the COVID-19 situation, particularly in the context of Philippine laws. So before I continue, I would like to let everyone know that this presentation was with the assistance of one of our underbars, Ana Regina Regalado. Let us all wish our lawyer hopefuls as they
Yes,
receive the
it will be
results.
soon
Kailan ba
released.
sa 29, no?
That's
Attorney
on Wednesday.
Julius,
That's on
29?
Wednesday. That's on Wednesday.
Yes.
Yeah, that's on
So
Wednesday.
Anna, I don't know. Yeah, Anna, I don't know if you're
She,
listening,
she,
but thank you. I would
she'll make
I
it.
would
She'll make
also
it.
like to. Yeah, yeah. I'm pretty much sure. Uh, I also would like to let everyone know that parts of this report and a number of the substantive portions came from a webinar conducted by the Asia Pacific region, composed of member firms and offices of Baker and McKenzie. So if you want, there are also materials available in the website of Baker and McKenzie. Kisumbing Torres is a member firm of Baker and McKenzie. Okay, um, I think I just have 40 minutes. At the end of this discussion, I hope to um, be able to impart what parameters are involved when people invoke or people refer to force majeure, what the Philippine law uh, definition of force majeure is. And then I want everyone to have an idea of some best practices approach to these issues. And then if we have time, we can go over some of the questions asked in the webinars conducted by the firm, because perhaps the answers to those questions may also answer some issues that people listening to the webinar may currently have. Okay? I don't
All
intend
right.
to I don't intend to devote much time in discussing what the COVID-19 situation is, because we are feeling its effects. So more than the fact that we are forced to have long distance relationships, so to speak, forced to work from home, real is the very real realization that this COVID-19 has ongoing effects on businesses and is expected to have lasting effects moving forward. Okay. What is important to know about the COVID-19 situation in the Philippines is that this any effects on contractual obligations finds its root back in March 16, when the president declared a state of calamity and enforced an enhanced community quarantine beginning March 17. Okay, so the ECQ was throughout Luzon, but thereafter, local governments and agencies followed suit with their own set of restrictions. So basically, when we talk about ECQ, when we talk about the COVID-19 situation, we are talking about at least three features of the said quarantine. First is that there is a strict home quarantine in households limiting movement to accessing basic necessities. Okay, so very familiar. The social media is rife with incidents of people getting in trouble, basically, with checkpoints and so on. Okay. The second key feature is that operations of private commercial establishments have also been limited. Okay. Especially during the initial phases of the ECQ, these were limited to those providing basic necessities. And then something that is still in effect, although being modified from time to time, is the suspension of mass public transportation and restrictions on land, air, and sea travel. I guess this is one feature that is probably underestimated by a lot of people, but the effects on supply chains, for instance, the effects on manufacturing, the effects on businesses which rely on mobility of people, mobility of products, is largely caused by these restrictions. Okay. This slide is to share to you some observations, at least in the Asia Pacific region, which the different member firms of Baker McKenzie have observed. I won't go into much details, but just enough to let you know that the effects of COVID-19 are felt even outside the country. Okay, so our colleagues have seen postponements and cancellations in terms of events, trade shows, and exhibits. So as you can imagine, the effect of these would be issues on payment of venue, issues on reimbursement of costs for services already mobilized. Okay, and then in the manufacturing and the supply chain, the travel restrictions are the main cause of impact on goods and manpower. Construction, the main issues right now are possible claims for extension of time due to delay in delivery of materials and equipment. Possible extensions, possible claims as to costs are also being commonplace. In the realm of consumer goods and retail, changes in consumer behavior directly affect the nature of services provided, if not the financial well-being of some clients in this sector. And then commodities, exports and imports are affected. Tourism, hospitality, transport, and airlines is basically suffering from reduced numbers of customers and dwindling demand. Okay, without further ado, let us now go to what this force majeure is. So if you are in-house counsel, if you are a business owner, if you're external counsel joining this call, force majeure may already be a common term, generally being thrown around, especially in these times. Okay, what I want everyone to understand at the end of this portion is that force majeure is that COVID-19 is not force majeure per se. The invocation of force majeure is actually an invocation of a technical concept that is to be viewed as a mere exception to a general rule. Okay, so malinaw po ba? Whenever we throw the word force majeure, we are actually invoking an exception to the general rule, which is that contracts are the law between the parties. Okay, and that obligations arising from contracts have the force of law between the said parties and should be complied with in good faith. So any analysis of force majeure should start with the premise that there is a contractual obligation between the parties. The parties should comply with it. What does force majeure mean to begin with? So it's a French term. Basically means it is basically equivalent to our concept of fortuitous causes, casa fortuitus. It is interchangeable when you look at our jurisprudence. It basically means that these are events which could not be foreseen or which, though foreseen, were inevitable. Okay? So that is the exception to the general rule on compliance with contractual obligations. It says that no person shall be responsible for those events which are considered fortuitous events or force majeure. Okay? An exception to the exception. So I am now addressing perhaps the non-lawyers from the audience. So marami kaming mahilig kami sa mga ganyan, the general rule and exception, and then the exception to the exception, which basically reverts back to the general rule, if you think about it. So the exception to the exception, which is force majeure, are three cases specified by law, when it is stipulated, or when the nature of the obligation requires assumption of risk. We will discuss these later on. So as a concept, force majeure is simply an event which the parties did not foresee or could not avoid, which makes it impossible to fulfill the obligation in a normal manner. Okay? Sige. As with anything legal, the Supreme Court has set forth parameters or elements by which invocation of a force majeure may be allowed. Okay, so merong parameters ang Supreme Court to determine whether a party may be excused from complying with an obligation on account of an alleged force majeure event. Okay, so number one, which is very important, the event claimed must have caused the breach. So merong element of causality. Okay. Next, the event must be either unforeseeable or, if foreseeable, was unavoidable. Next, the event must render it impossible to fulfill the obligation in a normal manner. So let's pause there for a bit. Is it absolute impossibility under Philippine law? It would appear not. Okay. So long as the cause of what was caused by the event was impossibility to fulfill the obligation in the normal manner contemplated by the parties, that may be considered as a force majeure event. Okay, so it's not really total impossibility, but impossibility to perform the obligation as contemplated by the parties when they agreed to their contractual obligation. Okay. The third element is the third and fourth elements have to do with the lack of fault or negligence, any participation in or aggravation of any injury that will be caused by the non-performance by one party. Okay, so dapat walang kinalaman yung nagki-claim in one, causing the event which caused the breach, or two, in the injury resulting from the breach of the obligation. Okay. Perhaps it will be better to conceptualize it in this way. So when we're talking about invoking a force majeure exception, we are talking about looking at three aspects of an obligation. Okay, so first you look at the event. Okay, ano bang event na sinasabi nyo na nag-cause ng failure to comply with the obligation? Okay, this is something that I will also repeat later on, but COVID-19 per se is not that event. So the event, as shown by the arrow leading to the obligation, should be causally connected. Dapat merong cause and effect relationship, yung event and the obligation which was not complied with. So, for instance, the obligation not complied with was failure to deliver the items bought in a certain transaction. If you are claiming that, an excuse from that obligation to deliver, you have to trace it back to the event which directly resulted to that non-performance. So, is it enough to say na dahil sa COVID-19, hindi ko na-deliver yung items which I was supposed to deliver? Probably not, because it doesn't really show a causation. Perhaps because of the ECQ, which prevented my drivers from passing through checkpoints because we are not an exempted industry, I was not able to deliver the goods that I was supposed to deliver. That would be a causality. That can be the basis for a force majeure event. Okay, so you look at the event, you ask yourself if it's unforeseen, you ask yourself if foreseen, it is unavoidable. Later, we have a case where this was discussed by the Supreme Court. So there, you look at the event, you look at the causation between the event and the obligation that was not performed. And then, of course, you look at the obligation. Has it resulted to impossibility of performance as contemplated by the parties under the obligation? And then lastly, you don't just look at the event and the obligation, you look at the party claiming exemption and see if he had any participation or anything done that might aggravate the situation. Because if there is, force majeure may not be available. Okay? Something to note about this lack of participation or no aggravation of injury caused to the other party, I think that the safest way to think about this is it doesn't merely contemplate a positive obligation not to aggravate. It may also cover a passive obligation in the sense that perhaps what the law or what a court may later on be looking at or looking for are things that the claimant could have done to mitigate the injuries to the other party resulting from the breach. The mindset being that anything done to mitigate will, of course, help the other party. The flip side being anything done that could have been done to mitigate but were not done may be seen as an act aggravating the circumstance. So later on, one of our best practices would be to do something that will mitigate the situation before even considering invoking force majeure. Okay, we now go to the exceptions. Sabi kanina, di ba, parang except in cases specified by law, a party shall not be responsible for force majeure events. So this is the exception to the exception, meaning even if it is a force majeure event which caused you to be unable to perform your obligation, if by law it says that you are still liable to perform certain obligations, you will be liable. Okay. at the outset, I would like to cite that one of the examples here, which members of the PMAP will be very familiar with, would be issues on employment contracts. So, for instance, it is not directly comparable with commercial contracts in terms of invoking force majeure, meaning despite force majeure events like let's say the quarantine restrictions, which may affect employment contracts, the paramount guideline would still be to comply with what the labor laws and regulations require an employer, for instance, to do, notwithstanding a COVID-19 situation. So, in a way, employment contracts are actually a carve out from the force majeure provisions of the Civil Code. Okay. Next, some examples would be found in the Civil Code. So, even if there is a fortuitous event, a force majeure event, if you are a possessor of property in bad faith and that property was lost or deteriorated, even if it is caused by a fortuitous event, that possessor in bad faith will be liable for such deterioration or loss. In sales, if what you are selling has hidden faults at the time of the sale, even if that item becomes lost through a fortuitous event or even through the fault of the buyer, the seller may still be liable to return the price which was paid less the value of the thing when it was lost. And lastly, if there is delay or there is an incident of double sale or double delivery or promising to deliver the same to two or more persons, anything which happens to that item, even if caused by a fortuitous event, the seller will be liable. Okay, the person in delay will be liable. Okay, so those are examples of cases specified by law, which are exceptions to the exception to the general rule. How about when it is otherwise declared by stipulation? Okay, what does it mean? It simply means that parties are actually allowed to modify a force majeure scenario by contract. Okay, and later on when we talk about the best practices, in fact, this is the first thing that you will look for, that you will consider whenever you are confronted with an issue arising out of COVID-19. You look for what the parties stipulated in their contract as to what constitutes a force majeure event, how it may be invoked, and so on and so forth. Okay. Later on, we will discuss a case where the Supreme Court, which is, I think, something unique from the other Asian countries, where the Supreme Court clarified that the parties may in fact broaden the scope of a force majeure incident according to their contract. Why do I say that this is different from other countries? Because other common law countries, like for instance Malaysia, requires that the force majeure provision in the contract be present before the parties may even be able to allowed to invoke force majeure. And the force majeure provision should be consistent with what the law provides. So, insofar as Philippines is concerned, the parties can actually define what a force majeure event is, when it may be claimed, and so on. So that is a stipulation, meaning if the parties stipulate that despite the happening of a pandemic, the obligation to pay is not affected, then that will govern. Okay. I have encountered, I've been advising one client which has this provision in place in one of their contracts, a specific provision saying that a force majeure event doesn't affect the obligation to pay under that contract. So it is possible. Okay, let's go now to the last exception to the exception, which is force majeure. What does when the nature of the obligation requires the assumption of risk mean? Okay, so it simply means that by the very nature of the obligation, the force majeure event being invoked is actually a risk that is assumed by the parties. So an example of this is the case of Mondragon Leisure, and this is one of a series of cases involving the Asian financial crisis. Okay, the next two cases that I will discuss have to do with the lessee pre-terminating a lease agreement on account of the 1997 Asian financial crisis. Okay, so spoiler alert, the Supreme Court did not allow invoking force majeure in these cases. So for instance, in Mondragon Leisure, the main reasoning of the Supreme Court was that every business venture involves risks. Risks are not unforeseeable, they are inherent in business. So what accounts for the statement by the Supreme Court? It's because the risk that is being claimed as a force majeure event by Mondragon was an economic risk. So in this case, I'm not saying that this will be the ruling of the Supreme Court in all cases, but in this case, the Supreme Court found that an economic risk, such as the happening of a financial crisis, is not really something that constitutes force majeure. In fact, the Supreme Court says that in the context of the subject contract of lease, which was a lease of a casino, this was an assumed business risk. A financial crisis is an assumed business risk. Okay. Another case is Com Glasgow, also involves pre-termination of a lease, citing business reverses resulting from the 1997 Asian financial crisis. So in this case, what the Supreme Court noted was that when it entered into the lease, it was already more than 3 years after the 1997 financial crisis. So it was an example of the nature of the obligation being involved in that case, being one that required the assumption of that risk, which the lessee claimed to be a force majeure event. Okay, so that is force majeure. Okay, there are related legal concepts to force majeure, which may have the same effect, but I think in the context of COVID-19, these are concepts that may be paired with invoking force majeure, or if not, alternative concepts that parties may see themselves exploring. Okay, one is the concept of a legal or physical impossibility found in Article 1266. I won't discuss this further. Perhaps you can just review this when you receive the slides, which you will. One thing to note is that this involves obligations to do, okay, and not obligations to give. Okay, so and it involves absolute legal or physical impossibility without the fault of the obligor. So again, sort of similar to force majeure, but with some nuances. The best example I can give would be, for instance, a performer, an artist, scheduled to perform on a certain date, but with the happening of the ECQ guidelines, is legally and physically impossible to do that performance. Okay, so aside from force majeure, if there's an issue, later on, he may also rely on 1266 to release him from any effects of non-compliance with that obligation. Okay. Another one, which is less popular, is difficulty beyond the contemplation of the parties. So this actually is related to those nerds out here. Is related to the international law principle of rebus sic stantibus. Okay, it is related to, but in Supreme Court cases, you will see that our civil code provision on manifest difficulty is not a direct equivalence of the principle of rebus sic stantibus. So in our context, it also has to do with obligations to do with services. Okay, and the difficulty must be so difficult so as to go into the intention of the parties when they were contemplating the contract. Okay, so again, in the case of Comglasco, this was one of the articles invoked. The Supreme Court did not side with the lessee and pointed out, again, what we said earlier, that the Article 1267 cannot be invoked because it is not manifestly beyond the contemplation of the parties when they entered into the said lease agreement. Again, harping back to the fact that it was 3 years after the financial crisis when the lease was entered into. Therefore, the parties should have contemplated the financial reverses in the said during the said period. And lastly, a related concept is the concept of loss and destruction of subject matter of contracts. Okay, so first, I don't know if I have sales students here. I think some registered, but I hope they remember that when the subject matter of a contract is a determinate thing, okay, meaning something that is specific, okay, cannot be replaced with just any other thing. That is a generic thing, okay? If the said thing is lost or destroyed without fault, then the obligation to deliver is extinguished. Okay, perhaps to be to illustrate it better, if it was the delivery of if it was the delivery of a if it was the delivery of rice, okay, and then the sack of rice which was supposed to be delivered was lost or destroyed, the obligation to deliver rice is not extinguished, okay, because you can simply get some other sack of rice and be able to comply with your obligation. So that is a generic thing, okay. So in one case, a very recent case, 1909, where the obligation was to deliver one revolver Smith & Wesson caliber 38, number 154990, and then the ship carrying the said revolver sank due to a typhoon. The Supreme Court excused the person delivering it from the obligation to deliver precisely because the obligation was to deliver a determinate thing. Okay, if the obligation was to deliver guns, then it would have been a generic thing. The obligation to deliver may still be in place. Okay. Okay, so I'll walk you through some cases. I'm running out of time, so I'll run through it quickly. So this 1915 case, very recent case by the Supreme Court. I will quote this extensively, only to show how the Supreme Court resolves these cases, and secondly, to show how your lawyers are tortured by the Supreme Court when they make these resolutions. Okay, so in this case, the lessees in Malate of a certain lessor filed a case for damages because their equipment, their merchandise were flooded because of an extreme torrential rain in 1913. So because of that rain, the building leaked and flooded. Okay, the Supreme Court held that the lessor was not liable for damages. Okay, first, there is no law providing for the liability of a lessor, notwithstanding an extreme torrential rain that causes its building to leak. There is no contractual liability as well, providing for a carve out to force majeure. And then lastly, and more importantly, there was no evidence of fault or negligence. Okay. So personally, I think this case may have been a case that turned on what was presented in evidence because, and I think most of the lawyers here will agree, it may be very possible to make a case that the lessor was somehow negligent, which resulted to the building being leased to the lessees to leak and flood. Okay, so this is how the Supreme Court resolves these cases. Very long explanations, but I hope it just demonstrates what the Supreme Court considers in force majeure invocations. So the Supreme Court looked for a law which would provide for liability despite force majeure. The Supreme Court will look for a provision in the contract which provides for liability despite force majeure instances. And then lastly, the Supreme Court will look at the evidence at hand. Okay, so one of the tips or best practices later on actually would be to document things as the COVID-19 issues happen. Okay, we can skip this. I will mention this next case, Globe, because more likely this may be the only case that you can find where the Supreme Court granted a plea of force majeure. Okay, so in this case, Globe successfully pre-terminated a lease agreement with Philcomsat slated for 5 years on the ground that the US bases left because of the non-renewal of the military bases agreement. Okay. So in that case, their contract contained a force majeure clause which expanded the list of events that may be considered force majeure to any law, order, regulation, direction, or request of the government, strikes, labor difficulties, insurrection riots, national emergencies, and so on, acts of God, etc. Later on, that would become an issue because Philcomsat would argue that force majeure, that the contractual stipulation of force majeure should be compliant with what force majeure is per law. The Supreme Court said that this is not the case. The parties are free to stipulate what they deem to be force majeure events, and that will be honored. Okay. Okay. I may probably end my discussion in this last slide because I've run out of time. But this last part will now veer away from the technical discussions on what force majeure is. We will now go into the practical considerations. Some best practices approach to force majeure issues. Okay, so to summarize, Um, the My suggestions on how to approach force majeure issues are the following. Evaluate whether there is a mandatory rule affecting your contract. Um, Check whether your contract has a force majeure clause and whether there is a procedure to be followed. Three, define the relationship. Later on, I will explain what that is. DTR for all the millennials out there. Fourth would be precaution and mitigation measures, documentation, and then lastly, which is very important, to check what other options do you have aside from non-compliance and invoking force majeure. Let's go to the first point. You first check if there is a mandatory rule affecting your contract. Why? Because especially right now, there will be regulations catering to a specific type of contract that, notwithstanding circumstances which may or may not affect the responsibilities of the parties, the parties will still be expected to abide by government regulations. So earlier we have discussed employment contracts. So they're governed by employment laws and regulations despite force majeure principles. Okay, so mere business reverses caused by ECQ arising out of the COVID-19 situation may not be sufficient to justify going below the minimum wages, for instance. Okay. Next, you have to check if your lease is covered by the Bayanihan Act, RA 11469, because under that law and the BTI Memorandum Circular 20-12, residential leases and commercial leases to MSMEs, medium and small scale enterprises, are entitled to a 30-day grace period to pay rent. Okay, so that is mandatory without you having to go through analysis of force majeure. And then lastly, loans right now are also subject to suspension of collection of loans for the duration of the ECQ and non-imposition of interests for those which will be suspended in terms of payment. Okay, so check if there's a mandatory rule affecting your contract. The next thing to do would be to define the relationship. Okay, so we skip. Sorry, I think I inadvertently skipped something. Hold on. Okay, sorry. The next thing to do would be to define the relationship. What do you mean by define the relationship? So what we need to keep in mind is that, again, when you are thinking of invoking force majeure, you don't just think of it as because there is COVID-19, I am entitled to be excused from my contractual breach. You look for the intervening cause, the efficient cause of the contractual breach, which is this question mark. So what may that cause be? It can be the ECQ resulting to a contractual breach, travel restrictions, lack of manpower, delayed supplies perhaps, and so on. So it's not COVID-19 per se, but what particular event arising out of COVID-19 has caused you to breach your contract. Okay, so that may spell the difference between you successfully invoking force majeure and not successfully invoking it. And then not just any contractual breach. So what we need to remember is that COVID-19 or the events arising out of it is not a blanket invocation for disregarding an entire contract. So we talk about what particular obligation was not complied with. So for instance, in a supply agreement, perhaps only the obligation to deliver will be affected. but not the entire supply agreement. So you ask yourself what particular obligation was not complied with, and what is the nature of the breach. Uh, is the non-compliance of a temporary nature, meaning only for the duration of the ECQ, but after it, you can, for instance, already proceed to deliver your deliveries, and there would be no further consequences in the contract for delivering past a certain date, because in that case, your expectations of what the effect of invoking a force majeure clause should also be tempered, meaning you may be looking at invoking force majeure, but only for the purpose of suspending performance for the duration of the ECQ. Okay, and then we go to precaution and mitigation measures. It is important to do this because of the risk that you may be seen as having contributed to the injury of the other party if you are found later on not to have instituted mitigation or precautionary measures. Okay, so remember the element per jurisprudence and law is that you should be free from any participation in or aggravation of the injury. Okay, why is it practical to do this? Because it is one way of dispute avoidance, for instance. So we have advised clients to notify in advance of an actual breach of obligation by sending a letter to the other party to basically say that we anticipate not being able to comply with so and so obligation because of the regulations arising out of the COVID-19 issue. We invite you to a discussion on this matter. So it can actually be a dispute avoidance measure, which is definitely the way to go. So we lawyers, especially us in the litigation department, safe to say, bread and butter would be disputes, but we really advise and encourage parties to avoid disputes, and this is one way of doing it. If there is already an ongoing dispute, um, mitigation measures may be a way of dispute management, meaning preventing the dispute from further escalating. So there is also the effect on the other party to see that the other party is in good faith trying to mitigate the situation. What do we mean when we say mitigation measures? Perhaps offering to source the supplies from some other supplier, if only to be able to meet the obligation to deliver, and so on. Documentation. It is important to document um, actions by the company, correspondences with the company and the other party arising out of any COVID-19 issuance. Because as earlier demonstrated, the Supreme Court cases can turn on what evidence was available. So what evidence are we talking about when it comes to these disputes? We can be talking about emails or correspondences showing how the impossibility of performance came about. Okay, so perhaps regular correspondences between the parties showing how the situation develops would later on be relevant for proving not only impossibility of performance, but showing good faith, showing lack of fault on the part of the party. Collating government issuances is an equally important part because you strengthen your position to a government issuance that harking back to a government issuance that is the cause of the breach of uh, contract. Okay, and then it's well to document company actions showing precaution and mitigation. So, for instance,
one of the issues that cost you
It looks like we have a technical difficulty, so are we okay now? Please stand by for, we're just fixing some technical difficulties here. We should be back soon. Our tech support is still doing something, so we should be able to be back on air in time. We don't have an audio.
sorry for that. Can you hear me now?
Yeah, okay.
Yep.
We can hear you.
Okay, sorry for that. Saan kaya ako hindi nadinig? Anyway, I'll just continue.
Yeah, go ahead. Just go ahead, Panyero. Go ahead. We'll summarize it later. Sige lang. Okay.
So the next item that I wanted to highlight was that the notices that we send, the notice of force majeure that we send to the other party may actually be a means of documenting the actions taken by the company, the causality between a COVID-19 incident and the obligation and the impossibility of performance. And perhaps later on, you can rely on the fact that despite having been notified of these circumstances and having had the chance to comment on the veracity of the claims or the facts stated in the notice, the other party failed to deny. So, pwede rin yun. Pwedeng mangyari na it can be proof of some sort of implied admission of the facts which are favorable to your cause. Okay? And then lastly, documentation of any agreement reached by the parties in discussing. So, um, sorry, is everyone seeing the presentation?
We can see Panyero, yes.
Okay, sorry. So any agreement that the parties arrive at in perhaps discussing how to deal with a COVID-19 situation should be reduced into something that may be presented later on and that the parties can rely on. Okay. My second to the last point. Hold on. Because I'm receiving all these messages saying, hold on. So I'm in presenter view. If I hide it, does it solve the matter?
You can hide the questions, Panyero, and we'll take care of it later. I'll keep on opening them, but you can hide it from your end.
Okay. Sige, I'll just continue discussing. My second to the last point before I end my presentation is to find out what other options there are to approach the issue. Okay, so it may not actually be invoking the force majeure clause. Okay, other options may actually be termination of the contract. Okay, one very good option would be to find out if further negotiations or discussions can be had between the parties so as to resolve any issues. My hunch is that because everyone is affected by the COVID-19 pandemic, parties are more or less pliable to uh, gaining concessions or giving out of concessions, volunteering some things which were not earlier agreed upon, if only to preserve commercial relationships, which is what is important, especially nowadays. So it's important to preserve commercial relationships. So in a way, medyo backseat dapat ang mindset ng litigation. But nonetheless, be prepared for any eventual dispute resolution. So to balance what I said, um, it's also equally possible that parties will not budge, so to speak, when presented with a claim for force majeure. So prepare for eventual dispute resolution, eventual litigation or arbitration by documenting everything that will help you uh, be excused from your obligations later on of you, or if you are on the other side, to help you oppose any claim to be excused. Okay. This one I will no longer discuss, but I will share it to you via the slides. So I hope I was able to impart some things on the matter. I think I turn this over to Attorney Julius.
Thank you very much, Attorney Jared. Thank you very much for enlightening us on the law on contracts, particularly the effect of force majeure. So now we know that the general rule is a contract is the law between the parties. But during force majeure or fortuitous events, it exempts one from performing his obligation under the contract. So the exception and to the exception is when the law makes it the person liable, meaning in those cases where the law expressly specified that the obligors must still comply with its obligations even during force majeure. The exception to the exception number 2 is that when it is agreed upon by the parties that one has to perform his obligations under a contract even during force majeure, or when the nature of the obligation requires the assumption of risks. Majeure, you also explained that while the law exempts the debtor from liability under the contract in case of force majeure, it must be established that one, the breach of the obligation must be independent of the will of the debtor, meaning he was not at fault and it is beyond his control. Number 2, that even if it is, it must be either unforeseeable or unavoidable, and the event must render it legally impossible for the debtor to fulfill his obligation in a normal manner. And as you said, the obligor should take mitigation measures, and that he should be free from participation in or aggravating the injury to the creditor. I have some clarifications, Sana Panero, but it takes that we're running out of time. So let's look at the questions from our viewers. Here's a question here from Vince Padilla. Non-operation of restaurants, which leads to non-payment of rental fees. Is that force majeure? What do you say, Panero?
Sagot ako, Attorney Julius,
Sige lang,
then
go ahead.
feel free to say
Go ahead.
something.
Of course, of course.
Actually, This is a very good question. And just to let you know that this actually has been a question raised in one of our webinars. The issue of lease payments. It is tricky, and the um, general answer to this really would be lease payments may probably be not excused by virtue of non-operation, for instance, of an establishment arising out of a COVID-19 incident. Why is that? Because if we think about it, the force majeure that we are talking about is pretty much defined, but the obligation that is affected by that force majeure scenario, in this case, would be the obligation to pay. So unless the claimant is able to demonstrate that he is totally unable to pay the rents, I doubt that that will be considered as an excusable scenario by virtue of force majeure.
In,
Because, yeah,
yeah,
Attorney Julius.
in addition, Panyero, the Republic Act 11469, the Bayanihan to Heal as One Act, only gives the tenant a grace period of 30 days. And so it does not excuse the tenant from paying rentals. You're only excused from paying rentals for 30 days. It's not an extinguishment of an obligation to pay at all. But I think Ayala Malls and SM, they said that they're not going to collect rentals. So it is something now subject to negotiation, as you have said a while ago, na pwede naman sigurong you can negotiate with your landlord. So there's another question, Panero. Since from Albert Lee, since we cannot deliver the goods and the services to our clients during the lockdown period, it means that it is fine. Is it okay to breach our contract? Are we legally liable for this unfortunate event? Or should our obligations still be after the lock, or we should we still comply with our obligations under the lockdown? So what do you say, Panero?
Okay,
So
so
yeah.
ako po tingin ko pwede po. It's possible to be excused from the performance of the obligation to deliver your goods, provided that we go through the elements of force majeure. So in your particular case, you need to be able to identify the event which causes you to fail to deliver. Okay, I would say perhaps that would be the transportation restrictions. And if you are able to prove that, that can be part of the narrative on how your obligation to deliver could not be done. Okay, whether it totally excuses you from delivering, or it just suspends your obligation to deliver, will depend on your particular contract. Okay, so there are contracts that perhaps are time bound, meaning if you don't deliver it within a certain time, then there's no use for it. If that is the type of contract that you have, then perhaps you may be looking at a total exculpation or total excuse. But if your obligation is not really time bound and it can still be delivered later on, then perhaps you can just be looking at suspension of that obligation, perhaps not being liable for penalties for failure to deliver on time.
So okay, there's another one, Panero, an anonymous attendee. If there is no provision in the contract that force majeure is not an excuse to implement it, can you invoke force majeure?
Okay, the
What do you
answer to
say?
that is yes.
Yeah, so
Uh,
bylaw.
so the answer to that
Bylaw.
is yes. that is one unique feature in the Philippines, that even in the absence of a contractual provision in force majeure, you can rely on the legal provision which we just discussed, which is Article 1266.
All right, there's another one from an anonymous attendee. Are there laws favorable to lessees during the happening of a fortuitous event? Because it seems to me that our law sides more with lessors. Sandali, hindi namin masagot yan. I'm sorry. That's up for the government actually. Sandali, there's another one. So, this is more on the labor aspect of it. But yeah, let's just read them. Hindi ito kasama sa ating subject on contracts. But if staff was under suspension during COVID, how will we go with this one? I know they are still our employee. I just send them a notice that after the ECQ is lifted, the investigation will resume, as well as the conference. Is that all right? Yeah, I think that's correct. You can continue with your investigation after the quarantine. Hold on. Most companies implement freeze hiring mandate due to COVID situation. Just checking legality or appropriateness in case these companies do not take these people now despite formal offer done. What do you say to this, Paniero? It's the company says they will implement freeze hiring due to COVID, but already they already previously, that is prior to the quarantine, the company already sent them a formal offer. Is the company still required to comply with its offer?
Ako, Attorney Julius, ang tingin ko, it will depend on the circumstances, particularly on na-accept na ba yung offer.
Correct. Oh. It doesn't say na in-accept ito.
Correct. Kung na-accept na. If na-accept na, may possibility po na baka dapat the company should comply, di ba?
Correct.
With its obligation to onboard them. And then, Attorney Julius, I also see an issue of, syempre, yung entry niya, di ba? Parang if you are entering as a regular employee or one probationary,
correct.
may
No
also
work, no
be
pay.
another issue.
Correct. Oh, yeah, yes.
So it will depend po on the facts.
That's correct. So, meron siyang follow-up question. Is the management somewhat obligated to have them in? No contract signing yet. With more reason. So it's just a follow-up of the previous question. It was just a job offer, and which candidates signed as proof of acceptance. So again, it will depend on the offer made, because if the offer was, we can consider it a contract already if it is already accepted by the candidates. But anyway, let's go to the third. Cite the crisis as the reason. Yes, you can cite the crisis. Number 4 is put the onboarding hold. He actually answers her question. They can still put them on hold. Okay, so there's one question coming from Chairman Nugid. What about international contracts where the international customer is canceling orders? Will it be dependent on the governing law stated in the contract, or Philippine law cannot be applied? So what governs, kumbaga, the governing law in the contract? So apparently, Paniero, the contract states that the governing law will be that foreign country, not Philippine law. What do you say to this?
That's a good question. No? Ganito po. It's important to know what the governing law of the substance of the contract is, because it determines things like if wala bang force majeure clause, will force majeure be available as a defense? or as a principle between the parties. Ang masasabi ko po ngayon is, ang alam ko lang po sa Asia Pacific, no? Pero not all the countries in Asia Pacific have legal frameworks like us na parang mix tayo ng civil and common law. So for instance, as I mentioned kanina, in some countries, kailangan meron kang force majeure clause for you to be able to invoke it. Wala sila yung kahit walang force majeure clause, we have the law, Philippine law to govern. So it depends po. If the contract is governed by another country, then you may need to also consult a foreign lawyer perhaps, or pwedeng Google siguro to find out more or less what the law of that country has to say about force majeure incidents.
Okay, so there's another question here from Willie Bongkaron, but this has nothing to do with the contracts. It's about employment law. I am not a lawyer and I don't know if this is valid, but can an employer summarily terminate an employment contract of an employee because of COVID? Citing this provision, ay nako, hindi pwede talaga. There is no such thing as summary dismissal of employees. The next one is, how about students not being able to stay in dormitories? Are we still liable to pay? Is it considered force majeure? Oh, this one, Majeure, this is about parang rental na rin to eh. How about students who were not able to stay in dorms? Are they still liable to pay the rental?
Alam niyo po, again, no, sadly, no, and gusto ko rin magdagdag dun sa mga points na sinabi kanina. Sadly po, parang all things being equal, kung yun lang ang facts, because of COVID-19, hindi ako makapunta dun sa leased premises ko, am I still required to pay the rental? Ang sagot po, kung yun lang ang facts is opo. You are still required. And siguro additional parang food for thought, na parang ito naman yung devil's advocate. Because technically, while while the lessee is not physically occupying the leased premises, nandyan yung mga gamit, di ba? Nandyan yung mga, let's say, equipment, if company, nandyan yung mga damit, if residential. So in a way, it also makes sense that the lessor still couldn't make use of his properties, even if you are not capable of occupying the property. So ako, ang suggestion ko dyan actually is really negotiate, attempt to negotiate, attempt to get concessions. Ako mismo, meron kaming pinaparentahan na parking space. Same situation din. Can't park, na inabutan ng ECQ outside the parking, di magamit na yun, pero negotiated na lang. Pero I was thinking to myself, if I really needed to assert my rights, then I can really collect for rent, because it's not like I can lease it out to some other person in the meantime.
Okay, there's a question from Riza Maranan. Is it legal for our contractual employees to work in lieu of regular employees who were not able to report for work due to fear of COVID-19, though our CBA states otherwise? Alam mo, would you like to answer that, Majeure? Because from my view, there's a danger here. While you can request your contractual employees to work because the regular employees are not able to work, yes, that is legal. But the danger there is since the nature of work of the contractual employee is such that they are already performing the work of the regular employees, someday you should just have to regularize them. Okay, there's another one.
I agree, attorney.
Okay. Can an employer cite force majeure or similar justification to postpone or rescind the engagement contract of a successful job applicant due to the reduced business operation? I think we already answered that kanina.
Attorney, highlight ko lang po, no?
Okay,
highlight ko lang po. So ang common dyan talaga sa mga employment issues is once meron na pong contractual, once meron na pong employer-employee relationship, it's not as easy as invoking force majeure let's say citing business reverses as a means of either terminating an employment relationship, kasi po mag-govern na ang employment laws na merong complete
Correct. Labor code na yan.
different from parties.
Right. So, from Maria Elena, is freelance contract, can it be terminated because of force majeure? What do you say to that, Paniera? Freelance contract.
Ako po una, di siguraduhin muna na freelance contract yan and hindi yan employer-employee relationship. So comply na lang po dun sa DO 174 yata ng sa labor. And then second, if totoo nga pong contract lang ito, it will depend on the terms of the contract. As I said, ang effect po ng force majeure invocation is not necessarily termination of the contract per se. It may be suspension. So, depende po yan sa nature ng service, let's say, o provide nyo, nature ng contractual stipulations, etc.
Okay,
Possible kung possible.
Okay, so we only have 2 minutes left. If an employee is retrenched during ACQ, hold on. We have already answered this. Okay. We have answered the questions. All the other questions are just repetitive. So what we learned today are very important in our way of doing business, especially to those who are professional, to those who are business owners, or to those who are in the management of businesses. We thank everyone for participating and getting involved in contributing to this lively discussion. We hope that this session will serve as a guide in your business and professional career to navigate through the uncharted COVID-19 territory. For more webinars, don't forget to like and subscribe PMAP's YouTube channel and other social media accounts. Again, on behalf of PMAP IR Committee headed by Attorney Wins, I would like to express my gratitude to Attorney Jared Amoroso for sharing his legal expertise and time with us. Thank you to our IR Committee members, the whole of the PMAP community, our technical staff, Sarah, Jeff, Jet, Kat, Maki, and Ali. Maraming salamat po. And wash your hands with soap for 20 seconds. You can just sing ABC and that's 20-second tune. Stay safe, everyone. Thank you.
Thank you, everyone.
Thank you.
People.
Yeah, thank you.
Management Association of the Philippines. People. Management Association of the Philippines.